In addition to protecting civil liberties, the Constitution also protects civil rights, and in this lecture we'll explore the concept of public discrimination. Public discrimination simply is discrimination by the government rather than by private individuals or corporations. When the Constitution was written in 1787, it reflected many different values, but equality was not one of them. Slavery was permitted to continue. And in 1857, in Dred Scott v. Sanford, the Supreme Court held that African Americans, even freed slaves, had no rights under the Constitution. Of course, that ended with the Civil War, and equally importantly, with the addition of 3 amendments to the Constitution immediately following the war. One of these was the 13th Amendment, which banned slavery. Another was the 15th Amendment, which prohibits racial discrimination in voting. But the important of these was the 14th Amendment, which made the freed slaves citizens and gave them the rights of citizenship. Most notably, the 14th Amendment says that no state shall deny to any person the equal protection of the laws. This is known as the Equal Protection Clause, and it represents the Constitution's commitment to equality. However, for more than 80 years, the Equal Protection Clause was undermined by rulings from the Supreme Court. The most important of these decisions was Plessy v. Ferguson. Plessy involved a law passed by the state of Louisiana that required whites and non-whites to sit in separate train cars. Despite the fact that this was clearly discriminatory, it was upheld by the Supreme Court. This established the separate but equal doctrine, which held that separating the races was not unconstitutional as long as the facilities were equal. This permitted the system known as Jim Crow, in which white and non-white citizens were forced to use different facilities. They were separate, but they were very rarely equal. This continued until the Supreme Court effectively overruled Plessy v. Ferguson and Brown v. Board of Education in 1954. In Brown, the court held that segregated schools were unconstitutional, saying separate is inherently unequal. Of course, this decision led to massive resistance, but eventually the schools were integrated, and the Supreme Court struck down many other instances of segregation. Today, government is forbidden from making racial distinctions when it makes decisions, with the exception of affirmative action. Affirmative action is giving preference to certain groups to make up for the effects of centuries of racial discrimination. The Supreme Court has ruled that they are acceptable in limited circumstances. But the Supreme Court has become more hostile to affirmative action over time and may prohibit it altogether.